all persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save this United States in this honorable court. Please come to order.
Right. Good morning and welcome to our District of Columbia Court of Appeals oral arguments. Sorry that we are delayed a few minutes in starting. As you know, we've been doing our arguments on this virtual Zoom platform in light of the COVID-19 pandemic for everyone's safety. We have three cases this morning before the court. The first is Derek Harris versus United States. Counsel, are you ready to proceed?
Yes, Your Honor.
All right.
Good morning. My name is Christine Pembroke. I represent the appellant Derek Harris in this matter. Before I start, I'd just like to say I'd like to reserve 3 minutes of my time for rebuttal. This matter is before the court on essentially 3 issues. One is the Monroe-Farrell remand question, and the other 2 involve claims of ineffective assistance of counsel. With respect to the Monroe-Farrell issue, this court has instructed in Johnson that the trial judge is obliged to appoint new counsel if there has been a complete breakdown of communication, and that the due process objective of the Monroe-Farrell inquiry is to eliminate the possibility of a hostile and ineffective representation. This court remanded this case for that Monroe-Farrell inquiry because it concluded in the plenary appeal that the trial judge had not sufficiently inquired into the attorney-client relationship. And on remand, the record demonstrates that, in fact, the relationship had completely broken down and that there was a hostile and ineffective representation. Trial counsel acknowledges in his testimony that, quote, he didn't know what Mr. Harris was going to say at times on the stand, that Mr. Harris had decided to testify over his advice, that Mr. Harris had told trial counsel he did not need to be prepared and that he did not need trial counsel's help.
Ms. Pembroke,
essentially, trial counsel revealed at the Monroe-Farrell hearing on remand that Mr. Harris was not cooperating with him in presenting his defense. The facts also suggest that there was a reason for this. Mr. Harris had said at the day of his trial and reiterated in the Monroe-Farrell hearing below that Mr. Harris felt pressured to take a plea by trial counsel, and that he did not believe trial counsel was engaging in any discovery.
Ms. Pembroke, can you hear me, Ms. Pembroke?
Yes.
I'd like to ask you a question or two about your theory that there's a complete breakdown in an attorney-client relationship. Long ago, I thought we maybe should create a doctrine of ineffective assistance of self. That is, sometimes the defendant is his own worst enemy. And why isn't this such a case where counsel tried to prepare him for cross-examination, and the testimony is that your client resisted that?
I understand what your Honor is saying, and I think the issue and the reason why that isn't the situation here is that because had the trial judge conducted a appropriate Monroe-Farrell inquiry, and I think Johnson talks about this, that where the relationship was doomed, if the trial judge had conducted an appropriate inquiry, she could have worked to try and patch the relationship so that the case could proceed.
And would she have done that by lecturing your client and say, there's nothing wrong with your lawyer. You need to pay attention to him and cooperate with him?
I think that if she had done a thorough inquiry, she would have found out that, Mr. Harris's concerns about discovery were not entirely unfounded, that trial counsel had sort of been dilatory in pursuing getting critical DNA evidence, that he hadn't investigated other witnesses, that he was only presenting in terms of evidence, the inculpatory evidence that would come out at trial, and not showing Mr. Harris that he had discovered any exculpatory evidence. And that hopefully she would have remedied some of these deficiencies as a result of a Monroe-Farrell inquiry. Had counsel done all of those things, I do think maybe she would have been within her, it would have been appropriate for her to remand Mr. Harris, that he needed to cooperate with counsel because counsel was doing a more than sufficient job for him. But the fact of the matter is, part of our claims on appeal are that he wasn't performing effectively. And that's why I feel in this case, and I understand your Honor's concern, this was not just a situation of the client being sort of not supporting his own defense. He obviously felt very strongly that certain things should be presented at trial, and he was not getting at least a sufficient explanation from trial counsel about why that wasn't happening.
Ms. Pembroke, I guess before we get to some of the specific claims regarding the witness and the DNA testing, I just want to ask one more question, sort of following up on similar questions asked by Judge Fisher. There's one point where the trial court asked the appellant twice if there is any part of the attorney's testimony that appellant disputed. This is in the remand hearing on the Monroe-Farrell. And appellant gave several responses, but he then says, quote, "Just come over more often and discuss with me the discovery." And, I was going through a whole lot at the time. And so it seems, some anxiety about trial, but nothing in that statement that really sounds in total neglect or a total breakdown. I mean, more often would seem to indicate that counsel was coming over to talk to him. Share more with me would seem to indicate that counsel was sharing and communicating. And then appellant says he was just going through some stuff at the time, which doesn't seem to necessarily be directly connected to what his attorney was or wasn't doing.
Obviously, there was some communication going on. It can't be disputed that trial counsel met with Mr. Harris a number of times. But it's also very clear from the record that they were having a fundamental disagreement about his defense, and that just caused Mr. Harris to shut down when it came to preparing for trial.
But were there some such disagreements? I guess if you were about to go to the DNA testing issue, I don't want to jump there too soon, but for example, on that question of whether trial counsel should have ordered DNA testing on the gun, counsel explained that he chose not to after speaking with Mr. Harris about the potential of Mr. Harris's DNA fingerprints being on the gun or on the inner workings of the gun.
Mm-hmm.
And trial counsel testified that after that conversation, Mr. Harris agreed that maybe it really wasn't a good idea to test the gun because I guess presumably Mr. Harris couldn't guarantee necessarily that in at least moving the gun enough to determine that there was a gun in the bag, his DNA wouldn't be on. I mean, that doesn't sound like a fundamental disagreement about what counsel should and shouldn't do. It sounded like Harris was ultimately okay based on that conversation. If you credit trial counsel's representations, which the trial court seemed to do here.
Right. Well, I think that there probably wasn't enough development in the record about what was going on that respect, because Mr. Harris also said that trial counsel told him that DNA evidence was not needed. So he was, to the extent he was agreeing that the DNA, they could forego the testing of the DNA. It appears to be that he was motivating that decision because counsel told him, we don't need to get DNA testing. It's also unclear whether or not, Mr. Harris was really given much option about this because trial counsel was so late in addressing getting the DNA and compelling the DNA testing to be done so that they could still go to trial on time. So Mr. Harris was sort of in a box. I don't think the record adequately reveals that Mr. Harris willingly agreed to all of this. Trial counsel had created a situation by failing to be diligent in getting DNA testing that Mr. Harris felt he had no choice. He was confronted with having to delay his trial date if they were going to get the DNA testing. And trial counsel knew that the government had nothing to gain by having that gun tested. The only thing it was going to show was that somebody else had handled the gun, and it behooved him to move aggressively to make sure that the government was following through and getting those test results in time for trial, because it was very likely, in fact, the trial judge admitted that Harrington's DNA on the gun would have been of some benefit to the defense. I don't know that.
In arguing that there was a complete breakdown of the attorney-client relationship that the trial court should have inquired into in a Monroe-Farrell hearing, you highlight counsel's testimony at the 23-110 hearing about his not knowing what Mr. Harris would say if he took the stand, his not allowing himself to be prepared to testify. Did Mr. Harris, however, say anything to the judge that would have alerted her to those difficulties? I'm not recalling that he did. I mean, the court should have conducted an inquiry, yes, but the scope of the inquiry would have been guided by what Mr. Harris's complaints were. And did he say anything that suggested a complete breakdown of the relationship?
Well, he certainly
he didn't
that.
say counsel wants to prepare me, and I've said no because I don't trust him. Or he didn't say I refuse to tell my counsel what I'm going to say if I testify. He didn't say those things to the judge.
No, he didn't say anything quite that specific, but he did say, I don't feel prepared. I'm confused and I don't feel prepared. And he said that, I believe he said that at the initial hearing before the trial, and also he reiterated it at the 23-110 remand proceeding. I believe on page 19 of the transcript, Mr. Harris says that he just wasn't prepared. So, I mean, and the trial judge just didn't inquire of him as to why it was that he wasn't cooperating with Mr. Irving, with trial counsel. She didn't try and go down that road at all. So all we have is trial counsel's acknowledgement that there was a complete breakdown. And,
Right.
I'll just reiterate that Johnson says that's a reason for appointing new counsel.
Did you just say that trial counsel acknowledged that there had been a complete breakdown?
Well, he acknowledged that Mr. Harris was not working with him on his defense, that he wouldn't allow him to be prepared for testifying. I mean, to me, that's a complete breakdown when your client won't talk to you about what they're going to say on the witness stand.
One of the things I've noticed over the years, and I suspect the trial judge had experienced this a lot more than I have, is that a large percentage of defendants just want to postpone the day of reckoning. they're not psychologically ready. And why couldn't she fairly interpret what your client was saying as an aspect of that? You know, I'm dealing with a lot here. I'm not ready.
Well, she didn't specifically say that, and Mr. Harris does talk very specifically about the fact that he didn't feel his attorney had engaged in sufficient discovery in the case. You know, trial counsel also testified to the fact that his client wasn't working with him on preparing for the cross-examination. So I think that the facts on the record were that it wasn't just Mr. Harris not being prepared for the day of reckoning. It was that he was actually not prepared to go to trial because of the breakdown in the relationship between him and his attorney.
Ms. Pembroke, I know you reserved a couple minutes for a rebuttal. Was there anything else you wanted to mention briefly before we hear from the government and then hear your rebuttal?
Sure. Just very quickly with regard to the two issues of ineffective assistance of counsel, I think that the standard was in fact satisfied, that a reasonable attorney would have engaged in the kinds of discovery that were needed to go to trial, namely to interview a key eyewitness and to obtain evidence that Harrington's DNA was in fact on the gun. It was
Mr. Pryor, I believe, is the eyewitness that you're referring to. And there were, I guess, some issues and concerns about Pryor. I mean, he denied even knowing appellant, and then it turns out appellant's his uncle. And there were concerns by counsel about his credibility with the jury. And those were factors that counsel testified weighed in counsel's decision not to call Mr. Pryor.
So I guess your honor is focusing on the prejudice prong, and I would have to say that I understand that there were discrepancies and issues on which Mr. Pryor could have been impeached, but I think a reasonable attorney would have concluded that Mr. Pryor's testifying to the essential facts that Mr. Harris did not have the gun, that Mr. Harrington left it in the back seat and Mr. Harris discovered it there, would have been critical to corroborating otherwise on, you know, the testimony of his client, which was clearly appeared to be self-motivated and would have been questioned by the jury. So even though he could have been impeached on other issues, I don't think that a reasonable attorney would have concluded that corroborating those essential facts was unnecessary and that Pryor shouldn't have been called as a witness for those reasons. And I know the trial judge also concluded that Mr. Pryor would have testified that there would have been a brief detour to get a cigarette on the way to the police station, and that undermined the innocent possession defense. But again, detouring to get a cigarette was a matter on which reasonable minds could have disagreed as to whether that constituted immediately or not. And furthermore, trial counsel, if they was concerned about that, didn't need to examine Pryor on that issue and could have limited the examination to just the issues of how Mr. Harris came into possession of the gun. So I do think that Mr. Harris was prejudiced by the failure of trial counsel to conduct this reasonable investigation that had the corroborating testimony of Mr. Pryor come in and the DNA evidence showing Harrington possessed the gun come in. There would have been a reasonable probability that a jury would have reached a different verdict, particularly in light of the fact that they struggled with reaching the determination in the first place.
Ms. Pembroke, let me ask you to focus discreetly on your Strickland claim with respect to lack of DNA testing. Do you agree that we cannot on this record rule in your favor because we can't find prejudice without knowing whether Harrington's DNA is on the gun.
No, I don't agree with that, Your Honor. I feel that because the trial judge did not allow the defense to get that evidence for the evidentiary hearing, that under Upshur, the rules for evidentiary 23-110 proceedings and for reasons of due process, this court should have a presumption that Harrington's DNA would be on the gun. And the trial judge acknowledged that there would have been some benefit to the defense to Harrington's DNA being found on the gun. In fact, in closing, the prosecution argued that you didn't need to know whether or not Harrington's DNA was on the gun, because you shouldn't believe Mr. Harris that Harrington abandoned the gun in the car. So,
So you
proving that
think,
Harrington's,
you think a presumption carries the day? You have the burden of proof on this claim, and you think because of a lack of information, there ought to be a presumption in your favor?
right. I mean, how can you have an evidentiary hearing where the defense isn't allowed to get the evidence that it needs for the 23-110 hearing? You know, it is clearly the burden on the defense to get affidavits from people if they can, to present that at a 23-110 hearing. But in this case, they were precluded from getting the evidence that they needed. So, you know, if the court is going to take that position, meaning the trial court, then I think on appeal, there should be a presumption that Harrington's DNA would have been on the gun. And everyone acknowledged that Harrington had the gun at some point. You know, I mean, not at trial, but the government knew that Harrington had claimed the gun was his. So, I mean, I think that's a reasonable presumption to make in this case.
All right, thank you, Ms. Pembroke. We'll give you a couple minutes of rebuttal. We'll hear from Pelley at this time.
Thank you.
May it please the court. Good morning, Michael McGovern on behalf of Appellee of the United States. I'd like to start first with appellant's argument that there should be a presumption about DNA evidence. The issue here is not that appellant was precluded from all DNA testing. What the trial court actually did in this case was eminently reasonable. The trial court determined that the request for post-trial DNA testing couldn't be decided until it was determined whether or not it would even be material. And so it decided to address the questions that were relevant to that question. Do we need DNA testing? It answered those questions in the negative, and so therefore no DNA testing occurred. If this court were to disagree with how the trial court answered those questions, it would be appropriate for this court to remand for the trial court to reconsider or to finally consider its decision on the appropriateness of DNA testing in this case. There's no authority for any presumption that defendant seeks here that this court should assume for ultimate purposes of the prejudice analysis under Strickland that there was in fact Harrison's DNA on the gun. That would need to be shown by appellant after testing. The trial court properly rejected appellant's pre- and post-trial claims that his counsel was ineffective. Contrary to appellant's claims, the record shows the counsel not only conducted an adequate pre-trial investigation based upon the information available to him at the time, he made strategic decisions about the best way to advance appellant's innocent possession defense, met with the defendant multiple times to discuss the case and his proposed litigation strategy, and even obtained appellant's agreement with his strategy on certain issues appellant now challenges. Indeed, both of the decisions not to pursue certain evidence that appellant now challenges with the benefit of hindsight were the result of considered strategic decisions by trial counsel based on risk assessments that weighed both the benefits and the costs of pursuing or presenting such evidence. Decisions that, it bears noting, were either expressly or tacitly endorsed by appellant at the time. Appellant's after-the-fact attempt to challenge these strategic decisions now must fail because not only did trial counsel perform in a manner that was reasonable, but even assuming his conduct was deficient, appellant has not shown that there is a reasonable probability that there would have been a different result had trial counsel interviewed and presented testimony from former co-defendant Pryor or sought DNA testing.
Mr.
No,
McGovern,
Mr. McGovern, go ahead, Judge Fisher.
please go ahead, Judge Thompson.
I was just going to say that the record shows that the jury in this case asked a lot of questions and was in particular, as I recall, interested in whether they could find appellant guilty of possession of ammunition if he didn't know that the bullets were in the gun or something like that. You know the question I'm talking about, even if I haven't described it quite accurately. So it seems like the jury was interested in knowing whether Mr. Harris had handled this gun enough to know about the bullets, and that it seems that they were struggling a bit. And I'm sort of left with the feeling that this jury, if DNA testing had been done and it had shown that Mr. Harrington's DNA was on the gun, inside the gun, on bullets, might have had some inclination to credit the story about Mr. Harrington leaving the gun in the car and Mr. Harris trying to take it to the police station. And as Ms. Pembroke says, there might have been jurors who, despite any instruction on an innocent possession defense, thought that stopping off for a single cigarette, perhaps to feed an addiction, was not so much of a detour or a lack of immediacy in going to the police station, that maybe Mr. Harris shouldn't be deprived of an innocent possession defense. And so maybe there might have been a different outcome. Dispel my concern about that, if you would.
So, Your Honor, the innocent possession defense requires not only that he obtained the gun and didn't have the intent to possess it criminally at the time, but that he was going to take it as quickly as possible, as soon as and as directly as possible.
Right.
And in fact, that was one of the things that may have been that shows why Pryor's testimony would have been problematic, is because without Pryor's testimony, no one put in the detour to get the cigarette. And so it was actually Pryor's testimony that advances this additional defense to the innocent possession defense. So it's a reason that Pryor's testimony is problematic, not only for the fact that Pryor was a horrible witness by all accounts and was impeached not only by his statements to the police, but by his inability to recall his story, that he was also impeached in the fact that he was inconsistent in significant respects with Harris himself, including on the timing of how long they had been together. Harris claimed they had been together for 3 hours. Pryor claimed that he had just picked Harris up just prior to the interaction with Harrington. So there were major discrepancies that would have called into question the incredibility of this testimony, which introduces to the jury this whole idea that these men are making it up. So it's problematic from that perspective. And the DNA doesn't answer that question. What were they going directly to the police station? And the evidence that is relevant to that wouldn't have been affected by the DNA evidence. The evidence that was relevant to that was the fact that rather than leaving the gun in the bag, Harris had tucked the gun not only inside his waistband, but actually deep inside his pants into his crotch. Harris was admittedly on 3 different types of narcotics, and yet was testifying that he was asking someone who had just been involved in a drug deal to take him to a police station, where he was going to walk into this police station with the gun tucked deep inside of his pants to turn it in, despite the fact that he knew that he wasn't able to have a gun at that time. And added to the fact that there was no 911 call. There was no call to the police station or to 911 to tell them that they were coming in with this gun. None of that evidence, which is strong circumstantial evidence that his intent was not to take this to the truck, would have been affected by the DNA evidence. And so whether the DNA evidence would have shown that the gun had in fact at some point come to Harrison was not the focus of the government's argument against Harris's innocent possession defense. The focus of it was none of this evidence supports his intent to take this to the police station. And so the trial judge, having heard all of that evidence herself at trial, engaged in a prejudice inquiry, which recognized that the DNA on the gun, even if it showed that the gun had come from Harrison, doesn't lend credence to the second part of the issue. I'll also note
Mr. McGovern, excuse me, if the jury thought the defense was as preposterous as you suggest, do you have a theory why they would have written the note that Judge Thompson asked about?
There was a question as to whether or not he knew the bullets were in the gun, but whether or not he knew the bullets were in the gun for purposes of him possessing those bullets doesn't relate to whether or not he had an intent to take it. So while they may have wondered whether one can be found guilty of possessing something they didn't have any knowledge was actually there, that is different than whether he possessed the gun and was intending to take it. So the question about whether or not one knows about those bullets doesn't address the question of his intent at the time to take it to the police station. And it just shows that they were being careful in going through the evidence and understanding precisely what the elements of each of the charges were and what were proper defenses to each of the charges. If there are no further questions on the ineffective assistance of counsel claims, I'd like to turn to...
I do have a question, if you'll indulge me. One of the strategic decisions that is attributed to Mr. Harris and his counsel is a suggestion that they had a discussion that DNA testing might actually hurt them because it might reveal that Harris had been loading the gun or handling the magazine, or you know the story. It seems to be the assumption behind that argument that if defense counsel had tested the gun and the results had been bad, he would have had to reveal those results to the government. Is that correct? Or do you think the government would have found out differently?
Your Honor, I don't think that his assumption actually at the 23-110 hearing, defense counsel explicitly testified that had the results been bad, he didn't believe that he would have been obligated to turn those over to the government if he didn't intend to use them. Certainly, if there was any intent to use them at trial, there would have been a discovery obligation for him to turn those results over. But this consideration was also wrapped into, one, the timing of the DNA testing, and also the question of whether or not the government could pursue its own testing. Because
if you'll indulge me a minute, when he was talking to his counsel, why would he say to Harris, this might come back to bite you? Unless he was acting under the assumption that bad news would have to be shared with the government.
Your Honor, I believe that he could have reasonably believed that the government could have discovered that bad news itself. Had he taken the time to test the DNA and the government was informed of that, there was nothing stopping the government from going forward with its own testing or getting its own expert to do DNA testing at that point. So the delay in order to conduct the defense testing would have permitted the government the opportunity to conduct its own testing. So there was a risk. It wasn't a 100% risk that that information would be provided to the government, but there was certainly a risk that whatever negative information he discovered, the government would then have the opportunity to discover as well. That risk combined with the fact that it was going to prolong the trial in order to conduct the testing, something that the defendant was adamant he did not want to do, in addition to the fact that in defense counsel's opinion, as we just discussed, the DNA testing the benefits from the DNA testing didn't conclusively establish the defense. And to the extent they may have somewhat corroborated it, the delay and the other negative risks associated with conducting the testing outweighed at that point the benefits that defense counsel reasonably saw he could have had from the DNA testing.
Let me ask you, if we were to remand for DNA testing, could we expect a meaningful result? And I ask that question based on two additional questions. Has there yet, 4.5 years later, been any swabbing of the gun that you know of? And two, do we have any prospect of getting a DNA sample from Harrington to add into the testing?
So, Your Honor, the government is not aware that any swabbing of the gun has been conducted at this point. And to Your Honor's point, there has been no DNA connected that the government is aware of, that I am personally aware of, from Harrington. And this was the case at the time as well. So it's not clear that Harrington was present even when defense counsel made a decision not to test the DNA. And so any result would not be meaningful, as it could show that without Harrington's DNA, the best result that appellant could hope for is a mixture of multiple individuals that includes him as a minor contributor. But it wouldn't indicate who else was on the gun or what that meant in terms of the timing of how other DNA got on the gun, particularly in light of the fact that then there would have to be a discussion of who else handled the gun and who else's DNA that could be, given that it was handled at the trial and could have been contaminated during the test firing as well.
Could you remind me, Mr. McGovern, of what the argument was about the robbery being disclosed to the jury? I remember reading about this a few times in the briefs, and I never could quite follow the argument. And now I have to say I'm at a loss for trying to recall what issue that was relevant to. Could you please remind me about that?
Yes, Your Honor. One of the reasons that DNA testing was not pursued was because defense counsel was concerned that if Harrington's DNA was in fact found on the gun, then Harrington, who during the original trial didn't appear at all other than through defendant's own testimony, but in the government's case had never been introduced in the case, would suddenly have appeared as an individual that they needed to explain. And the government and defense counsel was worried at that time that the government would have the ability to bring in information about why Harrington's DNA had been on the gun. And the allegations had previously been that Harrington had been robbed with the gun by these two individuals. And so he had a fear that the jury would hear additional information. And while it's not specific as to how or what evidence would have come in, it was a general fear that animated his calculus as to whether or not to do the testing, because at that point there was an uncertainty, and that uncertainty was not unreasonable. He did say he would have litigated to try to keep that out, but it presented a risk, and
Mr.
was yet
McGovern,
another of the factors to consider.
I guess it presented some risk, but it also presented some potential, arguably, to help Mr. Harris, because as I understand some of the circumstances surrounding this alleged robbery, I had understood that the three of them, Mr. Harris and the driver of the car and Mr. Harrington, this involved a purchase of marijuana that Mr. Harrington was supposed to be purchasing, didn't have the money, got out of the car, left his bag with the gun in the car, and Mr. Harris gets out to confront him about money for the sale of the marijuana, which Mr. Harrington didn't produce. And it then turns out that Mr. Harrington, as I understand the record, is the one that calls the police. When he doesn't pay, he's the one that calls the police and tells them that there's a gun in the car when Mr. Harris drives off. And it turns out, depending on who you believe, it was Mr. Harrington's gun. So it seems that there also is potential for that to be helpful. If the jury was already having questions about Mr. Harris's culpability at all.
But again, Your Honor, I would point to the fact that establishing that the gun had originally belonged to Harrington wasn't the crux of the defense. The crux of the defense lies in the fact that Mr. Harris intended to take that gun directly and as soon as possible to the police.
Well, but
And
because it
that-
wasn't his. I mean, I think it's hard to extract or dissect those two pieces, I think. I mean, the reason, if the jury is going to credit Mr. Harris's defense that he was turning the gun in, to me, it helps give weight to that if you understand the circumstances that it was supposedly Mr. Harrington's gun left in the car, and Harris didn't want anything to do with it, knows that he's on release and wants to get rid of it by turning it in as quickly as possible. It seems like that could have helped with the defense here.
But Your Honor, in this situation, I think what we have here is evidence that has a double-edged sword. Although that may have helped with that aspect of the defense, you also have Harrington as a negative. And Pryor, actually, in his affidavit shows why this is so. Pryor states that he heard a conversation where Harris confronted Harrington, and Harrington asked if his bag was still in the car, and Harris told him, yes, it is, and I'm not going to give it to you. And so that information, had it come in, could have been viewed by the jury as support for the fact that Harris was meaning to keep any of the materials that were in Harrison's bags as collateral until he received the money from the marijuana. So while there are aspects that may have supported defendant's case, there are aspects that would have supported the government's case or would have defeated the defense. And in those situations, you have a competent defense counsel who's making a reasonable determination that on the whole, he does not believe this is going to be helpful and the DNA testing is going to delay the trial. And so the choice around all of these issues is a weighing of both the costs and the benefits. And that strategic decision at the time is entitled to some deference. With respect to whether or not defense counsel was acting efficiently, and shows that he wasn't, because he was considering that there are that each piece of these evidence have multifacets. I'd just like to briefly, if I may, note that the theory that that the request for new counsel came from a complete breakdown in communications is a new theory that's being advanced now on appeal, but was not actually the focus in the trial court. As Chief Judge Blackburn-Rigsby noted, there is actually testimony that supports the fact that there wasn't a breakdown at all and that defendant would have appreciated additional communication. And as Judge Thompson noted, there just simply is no statement that indicates that the reason that he was not preparing with his counsel was because he was somehow intimidated with him or was not willing to work with him. Rather, the testimony about why he did that was because he didn't feel he needed to. And the final point I'd like to make is that the fact that a defendant may disagree with the manner in which a particular defense attorney might want to prepare for a particular strategic decision that a defense attorney might make, that disagreement in and of itself doesn't constitute a complete breakdown in the attorney-client relationship. If there are no further questions, we would rely on our brief and ask that the decision below be adopted.
All right, thank you. Ms. Pembroke, I think you reserved a couple of minutes for rebuttal.
Yes, thank you, Your Honor. Just quickly to address the ineffective issue, the question before the court is whether a reasonable attorney would have pursued getting the DNA evidence timely and would have interviewed a key eyewitness. Granted, there is always some risks associated with what you may find out in an investigation, and you may decide not to use it. But I think it's pretty clear that a reasonable attorney would have conducted those investigations, and therefore the first deficiency prong of the Strickland test is satisfied. As to the second prong, whether or not the attorney would have decided to introduce the evidence, I think that the concerns expressed by trial counsel about this evidence of a robbery coming in and that evidence not being helpful is misguided, because the risk of that happening is almost non-existent. The prosecution would have had to overcome a Drew Johnson inquiry in order to get that robbery information in. And again, as Judge Blackburn-Rigsby points out, that information may actually been helpful to the defense because it would have explained to the jury that what was going on and given them more context for what was happening. And with regard to the DNA evidence, while it is true that there may have been Mr. Harris's DNA on the gun, that can't really be, that wouldn't have been a surprise to the jury because Mr. Harris had the gun on his person when it was found. And I think that the government is speculating about whether or not we would have been able to get Harrington's DNA below. He was obviously in the criminal justice system. It's very possible, and he had felony convictions before. It's very possible that his DNA was already in the system. That was never investigated. And it was very possible that defense counsel would have been able to track him down once he learned that his DNA was in fact on the weapon and have been able to compel a DNA sample from him. So it's not clear at all that you would not have had Harrington's DNA at the trial. At the very least, we can assume that there would have been DNA of other individuals found on the gun. And that was important because the government argued in closing, you know, jury, you shouldn't believe Mr. Harris because you don't need DNA to conclude that he's fabricating this story about Harrington. So both Pryor's testimony as to the incident involving Harrington and Harrington's being present in the car and the DNA evidence would have been pivotal evidence in overcoming the jury's struggling and perhaps would have resulted in a different verdict. And I would also like to point out, yes.
Ms. Pembroke, do you agree that if we were inclined to remand for DNA testing at this point, we would have to get DNA from Harrington in order to make this a reasonable inquiry?
I think that the DNA for Harrington may already exist, but assuming that's the case, Your Honor, I do think being able to get DNA would definitely help the defense position. I'm not sure that it's necessary to say that the defense should be denied that evidence just because we haven't been able to track down Harrington and get Harrington's DNA.
Well,
the presence of
clarify for
others'
me.
DNA on the, I would say that the presence of others' DNA on the gun is sufficient to warrant
Help me with
allowing-
that then. The argument seems to have centered on Harrington. If we get Harrington's DNA off the gun, then that supports Harris's testimony and his defense. I don't understand why DNA from other people would support the innocent possession defense.
Well, the mere fact that there's the DNA from other people, and as Mr. McGovern pointed out, if it was shown that Harris was a minor contributor, would be strong evidence indicating that someone else possessed the gun. And that is consistent with the defense theory of the case that it was Harrington's gun. So it would be very helpful to know to what extent other DNA contributors were on that weapon, even though we could not necessarily specifically say it was Harrington's DNA.
Thank you.
Well, if there are no further questions, I would argue that Mr. Harris was definitely denied effective assistance of counsel in this case. And for those reasons, this court should reverse his convictions. Thank you.
All right, thank you. The court thanks both counsel for your briefs and your arguments, and the case is submitted. And you can feel free to exit our virtual courtroom at this time, and we'll hear first the case. The court thanks both counsel for your briefs and your arguments. and the case is submitted. And you can feel free to exit our virtual courtroom at this time, and we'll hear from All right, good morning, council. This is our second case today. This is in the matter of Selena Catlett versus DC Department of Employment Services. Council, are you ready to proceed?
Yes, Your Honor.
All righty, you can proceed, Mr. Snyder. Would you like to reserve any time for rebuttal?
Yes, could I please reserve 5 minutes for rebuttal?
Yes, thank you.
All right. Thank you, Madam Chief Judge. And may it please the court, I'm David Snyder. I'm here today on behalf of Selena Catlett, who is the injured worker in this workers' compensation matter. What brings us here today is the workers' compensation system, which is the safety net to protect workers and their families when they are injured on the job. Specifically, we're asking the court to view this case with that humanitarian purpose in mind and find two things. First, we ask that this court reverse the CRB's opinion in this case and affirm the CRB's May 21st, 2020 decision in the case of James Lyles versus Howard University Hospital, which was decided subsequent to the appeal in this case. In that
Mr.
case,
Snyder, that case, the Lyles case, is pending on appeal. And I wonder whether you think the appropriate thing to do in this case is to hold it, for example, to await a decision in that appeal, or to send this case back to the CRB for reconsideration in light of that May 2019 en banc ruling by the CRB. What's the appropriate thing to do in this case?
Sure, that's a great question, Your Honor. And I think that's ultimately up to this court. I think that these cases are so inextricably linked in terms of the issues to be decided that this court would like to make a coherent and uniform decision in both of them. And whether the proper route is to first remand this and have the CRB redecide it, only to have the appeal come back here, or to decide the appeals together. I think that either one would be appropriate just due to what the issues are and what's ultimately being asked of this court to decide.
Well, in addition to the usual factual distinctions that there always are between cases, this case and the Lyles case present the following distinction. In Lyles, the claimant had an injury when working for one employer, and then had another accident while working for Howard University Hospital. And the issue became whether, as the new employer, the hospital was entitled to apportionment so that it paid benefits for only a portion of the permanent disability. In this case, WMATA is not the new employer in that sense. It paid benefits for an earlier injury while Ms. Catlett was working for WMATA, and now now there's the issue of benefits for this new injury. And I wonder whether you think that the CRB's answer in its en banc decision is controlling in this case. And here's the reason in particular that I ask. In that Lyles decision, the CRB said something by way of defining what it meant by apportionment. And it said something like apportionment. Let me see, I wrote the language down here somewhere. Let me see if I can find it. Apportionment refers to the ability of a new employer to reduce its liability by an amount allocated for a previous injury. So it seemed to define apportionment as involving a claim against a new employer. And it left me wondering whether the CRB would think that this case is really about apportionment now that it has said that. And as we all understand, its ruling in this case preceded that en banc ruling in Lyles. So my question to you is, do you think that the CRB's resolution in Lyles and this court's eventual resolution of that Lyles appeal would necessarily control the outcome here?
Absolutely, Your Honor. The CRB, of course, is the appellate panel that is tasked with speaking as to its interpretation of the DC Workers' Compensation Act. Under Chevron, they're due deference in this regard. And the CRB has specifically stated in Lyles in the May 21st, 2020 en banc decision what its view is on apportionment. The other consideration in Ms. Catlett's case is really a credit issue. And that was not appealed by us because we believe that the CRB's determination as to the application of a credit to Metro for benefits previously paid to the same injury was appropriate. There's a 2018 case from the CRB in the case of Angela Brown versus Washington Metropolitan Area Transit Authority. The site for that, Your Honor, is 2018 WL 485-4481. And in the Brown case, the CRB spoke to the existence of a credit doctrine for employers when an injured worker has a subsequent injury to the same body part with that same employer. So Brown is really what is applicable here in Ms. Catlett's case, but at the same time, you can't resolve that without affirming the Lyles decision, because in Ms. Catlett's case, the administrative law judge, as affirmed by the CRB, applied both a credit as well as apportionment. So,
excuse me, Mr. Snyder, you've got to a key point that I'm scratching my head about. In this particular case, how would an apportionment and a credit work in combination? Or isn't the credit the big issue here? And what would apportionment change about the outcome for your client or for WMATA?
Sure, I've wondered the same thing, Your Honor, and I think the very fine distinction on that issue is if there were apportionment, which there's not. Apportionment typically deals with a credit, so to speak, for the percentage of the prior disability award, whereas the credit, as the CRB has said, is a dollar for dollar credit, regardless of what the percentage of disability is. Meaning that in Ms. Catlett's case, I don't remember the exact prior percentage, but if it was 5% and now the award is for 11%, under an apportionment theory, Metro would only have to pay the new 6% based upon the 6% of 234 weeks for the arm multiplied by Ms. Catlett's compensation rate at the time of the most recent injury. Under the credit doctrine.
I understand that in the abstract, but let's get down to dollars and cents. Does this make any real difference? Don't we have to calculate the dollar value of apportionment, compare that to the credit, and see if it's a meaningful difference?
If there were apportionment, I think that you would have to. But
because in part because the average weekly wage has an impact on this, doesn't it? I mean, if the injury for which Ms. Catlett was paid 5% benefits happened at a time when her average weekly wage was significantly lower than it was at the time of the subsequent injury, whether you apply apportionment or not could make a big difference. I mean, if there's no apportionment, then the dollar for dollar credit would apply, but the effect on the employer is that it effectively still has to pay some more money as to the original injury because of the new average weekly wage and then something on top of that. So it actually could make a difference.
Sure,
And it would go the other way if the average weekly wage were lower, I suppose.
Sure, and that's I was taking a little long to get to the point, Your Honor, and that's precisely the point I was trying to make. But what it comes down to is really the humanitarian purpose of the act, which is to compensate the injured worker for the effect on their ability to earn a wage. So in Ms. Catlett's case, her average weekly wage did increase in between the two incidents. So when she is paid permanent partial disability benefits under the aggravation rule, which is a longstanding principle in this jurisdiction, she's entitled to be compensated for the effects of this injury on her person and on her economic capabilities.
Mr. Snyder, I'm sorry, I wanted to ask a follow-up on this apportionment before and if we're finished with this portion, I then wanted to ask you about the details of how her injury was calculated by the various doctors that were credited.
Can I ask one other credit question before going there,
Mhm.
Chief? Thank you. I'm a little confused, Mr. Snyder, by your brief. At one point, you say that Ms. Catlett does not challenge the ruling on the credit to which the employer is entitled. But then in the last part of your opening brief, you have a lengthy discussion about all of the credits that might go to the employer. So there's the credit for the amount paid out for the first injury, and then there's a credit for some amounts recovered from a tortfeasor, and then there's another credit, which I guess is attributable to the employer's advance payment of monies for this injury. And you seem to be suggesting that something is amiss there, and yet there's your other sentence about how you don't challenge the credit. So I just want to nail down this point. Do we need to resolve these other credit points that you raise? Is that what you're asking us to do?
No, Your Honor, that was I'm looking at that page. I think you're referring to page 13 of my brief, which was really for illustration purposes and to show kind of how the calculation broke down, because you're right, there was a prior injury for which she was paid permanent partial disability benefits. Then Metro made a voluntary payment of permanent partial disability benefits as it relates to this. And we're not challenging that the credits for those were properly calculated both by the administrative law judge and by the CRB. What our challenge is not just to the use of an apportionment doctrine in general, but the use of apportionment in addition to those credits that Metro was properly permitted to take in this matter.
All right, thank you. Thank you, Chief.
Thank you. Mr. Snyder, this question goes to the Lyles decisions we talked about. And I'd be interested in your response to the argument from the intervener that there are really two co-equal CRB en banc opinions on this issue of apportionment. It doesn't strike me that way. That's the most recent CRB en banc decision clearly intends to decide the issue of apportionment and how it is or isn't applicable under our statutory scheme. And of course, that's the case that's on appeal that we were discussing earlier. What's your response to this argument that we had essentially two en banc decisions from the CRB going in different directions on the issue of apportionment?
Sure. So we do have two en banc decisions. That much is true. The later in time one, however, is what should be relied upon by this court for a couple of reasons. Primarily, the first en banc decision of the CRB was dedicated at answering a narrow question on remand from this court's mandate, which was whether the addition of section 32-1508-6C repealed everything prior to it. And the CRB really made its determination based on that limited question. When Mr. Lyle's case came back before the CRB, it now had the opportunity to speak to apportionment much more broadly. And the CRB saw the error of its prior decision and spoke to that. Specifically, I won't read you the full text of it, but the slip opinion from the CRB and Lyles at 10, the CRB devotes really 2 full paragraphs as to why it believes its prior en banc decision was incorrect. And it's for really 2 reasons. First, as a matter of policy. Second, as a matter of its more full review of the legislative history when given the opportunity to delve into that further. The other point the other thing I would point out, and it's somewhat confusing here, is in Ms. Catlett's matter, the agency did file a statement in lieu of brief in support of the CRB's decision a few weeks after Mr. Lyle's case was decided. In Mr. Lyle's case, which I think this court has recognized as pending before it as 20 AA 0405, on January 8th, 2021, the agency filed again a statement in lieu of brief in support of the en banc decision in Mr. Lyle's case. I think there's probably just really a practical reason for that in terms of the timeline. Nothing beyond that. But I think that's important because, again, the agency is constrained and tasked with administering and interpreting the act, speaking for what the law of the District of Columbia is, and its interpretation is due to deference, assuming that the interpretation is both articulable and reasonable, which it is in the May 21st, 2020 decision in Mr. Lyle's case.
All right, thank you. I was going to transition to the whether or not the ALJ's decision was arbitrary and capricious in terms of how it evaluated the injury, how it evaluated the testimony of, I believe it was Dr. Thompson and Dr. Gannett or Gannett?
Monet, yes.
Monet. And what those findings are based on in the calculation of the percentage of permanent partial disability. Can you persuade me why those determinations are correct and should not be reversed as the intervener argues?
Yes, Your Honor. And I note that my time has elapsed, so I'll try to be as brief as I can in order to address this question. So as this court knows, there are really 3 requirements that have developed under the law in a determination of permanent partial disability. It's the use of the AMA guides, the quote, Maryland 5 factors that were adopted into the act from the Maryland Workers' Compensation Act: pain, weakness, atrophy, loss of function, and loss of endurance. And then finally, the effect that the work injury might have on the injured worker's ability to earn an income.
Can I ask you about the AMA guide? Because Dr. Manette used the 4th edition and Dr. Thompson the 6th edition, and the statute says something about may use the most recent edition. What should we do with that?
There is there's a prior case decided at least a decade ago, Your Honor, on that specific question, and I don't have it handy, but I'm happy to search for it while counsel for the interveners is arguing. But that case says that the use of the word may in that context is the ALJ may use the AMA guides. The may does not go to the specific edition of the guides. They can use whatever edition they are most comfortable with. And I believe that Dr. Monet testified as to there's some stark differences between the 4th and 5th edition and the 6th edition in terms of the 6th edition really goes to a disability determination as opposed to medical impairment, which the doctor can evaluate the impairment, and disability is really a legal determination based upon many more factors than what the doctor is tasked with. But I'll certainly search for that case and
Thank
hopefully be
you.
able to provide that on rebuttal. Just to go back to Chief Judge Blackburn Rigsby's question. So those are the three things to look at. This was an error here for really two reasons. First of all, this court has said in Strawn versus Department of Employment Services that the administrative law judge has to consider the injured worker's testimony. And really that goes to when the administrative law judge is dealing with the Maryland 5 factors. There is no discussion of what, if anything, the administrative law judge credited in terms of Ms. Catlett's testimony about that or did not credit. There's a discussion in the compensation order as to what Ms. Catlett's testimony is. There's no adverse finding of credibility against Ms. Catlett, and then it seemingly just vanishes and isn't mentioned again. The other thing that I would point to is that I apologize, I lost my notes. There's suggestion in the compensation order and affirmed by the Compensation Review Board that Ms. Catlett is somehow abandoning reliance on Dr. Monet's opinions, which actually quite the opposite. Dr. Monet's deposition was taken. He was given the opportunity not just to elucidate his opinions from his report, but also to review and comment and ultimately incorporate into his determination Dr. Thompson's independent medical evaluation. And page 23 of the appendix, and the subpart would be page 18 of Dr. Monet's deposition transcript. He specifically lays out, in response to my questions, each of the individual factors that he relies upon in ultimately reaching the rating that was claimed at the formal hearing in this matter. So while the CRB notes that he was, quote, vague and limited on subjective factors related to the elbow and forearm, and as such insufficient as a basis for a rating of impairment, that's not at all what the record demonstrates. And in fact, it was much more detailed analysis. There was nothing vague about it because he went through point by point as to what his findings were, what Dr. Thompson's findings were, what his opinions were regarding medical impairment under the guides, and what his opinions were regarding the 5 factors.
Did either Ms. Catlett or Dr. Monet try to relate those percentages under a couple of the Maryland factors to Ms. Catlett's industrial capacity, to the effect on her work? I mean, part of her testimony was, well, you know, I used to use both hands to open the gate, and now I just use, my right arm to open the gate, and that's how I avoid that problem. And explaining his ratings, Dr. Manette said, well, you know, I listened to her complaints and her history of injections and other things, and I came up with those numbers. Did either one of them suggest that some percentage number bore a relationship to her ability to do her work?
Not specifically to that.
Is that
point,
a problem?
No, it's not. Because Dr. Monet indicated how he reached his opinions on the 5 factors. That's spelled out in the deposition testimony. And admittedly, that's kind of an inexact science for the doctors, right? They're relying on what is reported to them as well as their own kind of history and experience, right? Because the doctor has to say, am I giving this patient 5% for pain or 15% for pain? And what do I base that on? But more to that point, from a legal standpoint, long ago in DeShazo versus Department of Employment Services, that's 638 Atlantic 2nd, 1152 at page 1156, this court stated that the purpose of a schedule award is to compensate the injured worker for a presumed future wage loss. This has been kind of walked back a little bit over time, but because there's really 3 distinct factors to determine the AMA guides percentage, the 5 factors and any immediate effect on wage loss. And that's under the court's 2017 Dent versus Department of Employment Services decision. There does not have to be an immediate effect on an injured worker's wage loss in order for them to be entitled to something. But if there is, it's a factor the agency can consider. And if it's not, it's also a factor that the agency can consider. But I think looking all the way back through the purpose of a schedule award, it's that Ms. Catlett has spoken to problems that she has at work. And even though there's not an immediate impact on her ability to earn a wage, there are certain difficulties that she has that may at some point in the future come to fruition and affect that. And that's the whole purpose of a schedule award.
All right, thank you, Mr. Snyder. I know you reserved a couple of minutes for rebuttal, which we'll grant in light of the fact that our questions took you over time. Mr. Doe, are you ready to proceed on behalf of the intervener?
Yes, Your Honors. May it please the court. Mark Doe on behalf of the intervener, the Washington Metropolitan Area Transit Authority. Your Honors, you have 2 issues before you today. One of apportionment, which is a matter of law, and the second, nature and extent of the PPD award, which is going to be reviewed on the basis of substantial evidence. And obviously the elephant in the room is the Lyles decision that's pending before this court. And as a matter of law on the issue of apportionment, the present CRB decision below relied on the Lyles decision before the most recent en banc decision, which effectively ruled out apportionment. But the question on the issue of apportionment, which we believe that the court should still be able to address, is whether, absent the section 32-1508, the section 6, and the decision by the CRB in the en banc decision of Lyles to effectively decide that the subparts A and B were also repealed along with subpart C, effectively eliminating the entirety of the statute enabling apportionment, whether apportionment should exist as an equitable type remedy for the trier of fact when assessing the degree of disability. I think the caution of the CRB in many of the decisions below is whether or not the claimant without the idea of no apportionment would not be able to get their full benefit for the injury for the most recent employer. I think the idea of full benefit sometimes gets conflated with the idea of a causally related disability. PPD awards under the Workers' Compensation Act is an economic concept, and we have a lot of decisions on point. And the basis of the economic consideration is whether the permanent nature of an injury has or will have an effect on future wage loss. This court has addressed in prior cases such as Carolyn Jones, noting that the nature of PPD benefits, it involves a predictive nature with a complex of factors. So when we talk about the complex of factors and involved with also what the statute provides for consideration of permanent partial disability, you have the AMA award, the AMA guidelines, the subjective factors, claimant's testimony, age evidence, in this case, also evidence of prior disability. The evidence of prior disability is significant because it would, without apportionment, in many cases, what the award for permanent partial disability or the resulting disability would be an inappropriate or inapproximate awarding of all the pre-existing disability, which may have been awarded, may have been just never awarded, but is not a fair representation of the resulting disability for an injury with the most recent employer. The idea of
Mr.
Mr. Doe
Doe,
is, go ahead, Judge Fisher.
Excuse me, I understood your brief, or perhaps maybe I misunderstood your brief, to say that you are entitled to both credit and apportionment in a single case. Do you really mean that, or do you mean you're entitled to whichever one yields the greater benefit to your client?
Yes, Your Honor. So the idea of whichever one yields a better benefit is not necessarily to the client, the employer. It may also affect the benefit to the claimant. And you have to have both in order to determine what is a fair representation of the resulting disability. And credits as
But you're not saying you add them together.
no, Your Honor. And in
You're
this case,
saying you compare them and then select one or the other.
yes, Your Honor. And in
Thank
this case, the ALJ, I believe, using the language, which may be a little confusing, did exactly that. Awarded a credit, which was for the prior 5%, and also awarded the apportionment. So there is no, as claimant had argued, double dipping from the employer. And credits by its nature, as the established doctrine by the CRB, pre-existing this case, we cited Angela Brown and her mother, a few CRB cases, has to do with a dollar for dollar remedy for the employer to prevent unjust enrichment. Apportionment is a separate concept related to the degree of disability, the degree of impairment. And so there's possibilities, while there have been prior awards for a injury or disability, which could be reduced to a dollar amount, there's also scenarios, which is often the case, where an injured person has pre-existing disability, which has not been compensated in any manner. And so that pre-existing disability or impairment has to do with whether or not the percentage of resulting disability for an injury should fairly encompass the entirety of a pre-existing as well as subsequent injury, as far as the degree of impairment for which the employer should now compensate the employee. Now, in some
Well, those
cases,
are certainly important issues in cases where there's a new employer or maybe a new insurer, for example. But here, your client is not a new employer in the way we're using that word. So I'm having a difficult time understanding what the harm would be to your client if it gets a credit but no apportionment. The idea seems to be that for injury to this scheduled member, the arm, the claimant is entitled to the amount, an award that corresponds to the percentage disability in the arm. And if you paid her 5% years ago at a time when her average weekly wage was lower, and now you need to pay her another 6%, let's say, while her average weekly wage is higher, to really get her at this point in time to a level of payment that corresponds to her percentage of loss of use of that arm, why shouldn't you just take the credit, pay her whatever additional amount would be owing for the first injury because you paid her based on a lower average weekly wage, add that to the amount for the new average weekly wage and be done? Why do you need apportionment? That's the issue in Lyles, where we have a new employer, but it doesn't seem to be the issue here. And that's in part why I'm wondering whether we need to decide the apportionment issue here, whether we need to wait for Lyles to be decided or just what. So I have two questions to you. It's sort of what should we do with this case in light of the pending appeal in Lyles, and why on the facts of this particular case do you think that both apportionment and a credit are the appropriate way to go?
yes, Your Honor, I'll try to answer all those the questions that you have. First, I believe when you mentioned the differences or the distinctions between a subsequent employer and Metro, I think if you perceive it to be some type of what we'd argue unjust or unfairness to the employer is equal to a new employer versus an old employer. In fact, Metro WMATA has the experience of having the same employee have multiple successive injuries and multiple successive claims of permanency, to which without the tool of apportionment, there would be additional awards which does not accurately reflect the most recent disability. And I keep using the phrase resulting disability versus the idea of full responsibility for pre-existing impairments. And so when we look at also what Lyles focused on is a lot of the idea of apportionment was statute bound, section 32-1508. The section 6 and A talks about an injury to an employee when combined with a previous occupational or non-occupational disability or physical impairment. I know now we've decided that subsection C pretty much abrogates the subsection A and B, but the idea of apportionment is if it has a rooted basis in the functional equivalent in the statute, has to do with non-occupational disability as well. Yes, in some examples, the idea of a credit, if there was a prior determination, an award for disability, permanent partial disability to the same scheduled member, that credit would help the employer offset essentially some of the costs or recognize the pre-existing nature of a prior injury. But by acknowledging the idea that there is a credit, the trier of fact should also implicitly have the ability to acknowledge pre-existing degrees of impairment. So the other example Your Honor used was if an employee somehow is injured, is awarded a certain percentage based on a certain average weekly wage, wouldn't a successive injury at a different percentage, the employer would only because of credit pay the marginal difference. But without apportionment, technically, theoretically, there's also an instance, say a person was injured and had 10% disability to a body part that was equal to $10,000. Now, the idea of permanency is that there is a degree of permanent impairment to the functional loss of use, industrial loss, which would affect the wage earning capacity of that employee. So the idea that an employee would always earn more is not necessarily so. So if the degree of the impairment in the first award.
That's why I wanted to limit it to the facts of this case, because as I understand it, the employee is earning more now.
Yes,
So
Your
let's-
Honor.
Right.
But just theoretically, the idea of apportionment, whether or not that would not the credit would solve all the issues that apportionment would address. There would be an instance, say, if the claimant earned less and the employer was only given a credit, the employee was subsequently in a subsequent injury, injured to the degree of say 20%, but based upon a stagnation of the wages, or even less, that 20% based upon maybe with a new employer or inability to continue work at the degree that he was working before, is still only worth $10,000. So the employer would be able to take a credit for the $10,000, and the court, the trier of fact, would not be able to determine the degree of resultant disability, since the credit would negate any of the claimant's ability to earn, well, not to be able to allege an increase in permanent partial disability, in this case by 10%.
I understand what you're saying, but I guess I wonder whether the CRB doesn't need to tell us how it believes these situations should be handled, because again, my attention really focused on the fact that in Lyles, the CRB seemed to be addressing the new employer situation. In fact, as I mentioned earlier, when it defines apportionment, it says something like, this refers to the ability of a new employer to have its liability affected by, so I'm not sure that I know what the CRB thinks about this. And I wonder if you think you know, or how you think you know.
Well, Your Honor, I believe, even though it's a statute now, the CRB has ruled is repealed. Subsection 6A 32-1508 speaks about the employer, not a new employer or a subsequent employer. So what the Lyles decision what the CRB on remand from the prior court's decision was tasked to do was to interpret the availability of apportionment in light of the statutory repeal of that section, subsection 6A. So how the CRB on remand presently has framed it, I believe, is still up to the court to determine whether or not the CRB's decision, most recent en banc decision, is rational or reasonable in light of what the remand directive was.
It does seem possible that the court will have the opportunity to say only whether the CRB decision was rational with respect to facts such as those in Lyles, the new employer situation. And I guess I'm just not sure that we will know based on what the CRB said in Lyles and what this court will say in that appeal, what the answer should be here. And I wonder whether we should either send this case back to the CRB to tell us the answer, or we should, at a minimum, wait and see what the court says in Lyles. Which do you think is the best route to go?
I think, Your Honor, I think this court should wait and listen and have the arguments if that's where the Lyles decision is heading towards, and then consider both the case before you today in Catlett as well as Lyles. The facts are different, but the legal issues are essentially the same. I think what this decision, what the Catlett fact shows is what the employer's argument is that absent a statutory, a review of the statutory interpretation by the CRB as to 32-1508-6A, the employer's arguing in this case that apportionment is still a viable remedy, a tool for the trier of fact. For the reasons, I know I'm running out of time, but as reasons stated in the brief, to prevent or to create a fairness for both the employer and the employee on the awards of permanent partial disability. And just quickly, Your Honor, as to the secondary issue of nature and extent of disability, that's a review of the case on the basis of substantial evidence. As to the degree of impairment that was awarded by the ALJ, the basic facts of the case is that it's an IME versus IME opinion. There was no treating physician preference. The ALJ was very specific. What they found was inconsistent in the claimant's reliance on both the employer's rating as well as claimant's experts, Dr. Monet's rating, and the inconsistencies of rejecting Dr. Monet's opinion when he only rated a percentage of impairment related to possibly the elbow versus Dr. Thompson, who focused on the wrist. But the medical evidence shows in both, at least Dr. Thompson's examination, that he considered the elbow. The ALJ pointed out that in Dr. Monet's deposition as well as his opinion report, that he did not really consider the wrist. The factual history of the claim as documented in the medical records includes both. And I think substantial evidence governing the review of the nature and extent of the disability as far as an award should be affirmed as a matter of a reasonable view of the facts, and otherwise would be just re-weighing the evidence. And Your Honor, in conclusion, we would ask that Your Honors maintain the Catlett case in conjunction with the pending Lyles decision, because I don't think this is a case that necessarily has to just wait for the decision of Lyles to determine the fate of Catlett, because I believe the factual scenarios are a little bit different. What we are arguing is the argument for apportionment in light of even the repeal of the statutory provisions for apportionment, which I believe can be addressed in Lyles as well. So the complex nature of these types of claims, and the factual scenarios where a credit versus apportionment versus employer, a new employer versus old employer, I think should all be considered together, and it's helpful for the court to keep both cases in mind when deciding the upcoming Lyles decision. But otherwise, we would ask in the end that the award of the ALJ in this matter be affirmed. Thank you, Your Honors.
Mr. Doe, I just want to make sure I understood your last point, because I thought in relation to your response a moment ago to Judge Thompson that you favored holding off in deciding this Catlett case while Lyles is being heard for oral argument before this court. But then I just heard you say that you're fine with me affirming the decision in Lyles because the facts are different and it wouldn't necessarily impact what happens. I mean, the facts in Catlett, this case, are different and wouldn't necessarily impact the arguments in Lyles regarding the apportionment and credit.
I'm sorry, Your Honor, I might have muddled that bit. I'm asking the court to wait and decide Catlett in conjunction with Lyles, but in the end, I believe that Catlett's decision should be affirmed, in which case I'm asking the court in Lyles to find that apportionment is an applicable remedy for the trier of fact.
All right, thank you.
Thank you.
Mr. Snyder, you have a couple minutes for report.
All right. Thank you, Your Honor. Before I say anything else, I just want to circle back on Judge Thompson's question regarding the additions of the AMA guides. The case that is pertinent to this, I'm going to spell it. The injured worker's last name is Eskandarian. It's Eskandarian versus DC United. It's a 2011 decision from the Compensation Review Board, and the site is 2011 Westlaw 1841883. And specifically at page 4 of that decision, the CRB has a lengthy discussion. There were arguments as to whether one doctor had used the 5th edition of the guides, one had used the 6th edition. There were arguments as to what the meaning of the language in the act was. And what the CRB ultimately said is, basically what I said is it doesn't necessarily matter, but they said, while an ALJ could choose to give preference to a medical opinion based on the most recent edition of the American Medical Association's Guide to the Evaluation of Permanent Impairment, we see nothing in the statute that requires an ALJ to give priority or preferential evidentiary weight to an IME doctor's opinion that utilized the most recent edition. That's never been challenged either in that case or in any other one that I'm aware of. Again, deference should be given to the CRB for their interpretation of the act they're tasked with administering. And really, the only other thing I wanted to point to that I didn't get around to in my initial and the council referenced is just there's no statutory provision for apportionment. In addition, there's no equitable basis for apportionment to be written into the law, either by the CRB or this court, neither of which are a court of equity. And that's for a few reasons. First of all, the CRB has said there's not, as a matter of policy. Second of all, because of the humanitarian purpose of the act, if there is an interpretation that's going to deprive injured workers of something of more than their full, or they're going to be deprived of their full compensation that they're entitled to under the act, that would have to be explicitly spoken to by the council in drafting the law. And what the CRB notes is that has not happened. Their review is that it did not happen, and their interpretation is that that's not the case. So
until I looked at this case, I hadn't realized that the language of the public sector workers' compensation statute that that expressly directs apportionment was added only in about 2010, as I recall. I wonder what you think the impact of that provision is, because as I recall, our discussion of the humanitarian purposes of the act is made in the public sector cases as well. And yet there, the council has expressly provided for apportionment in recent times. How should we regard that in thinking about these issues?
Okay. So, first of all, the Public Sector Act is not what's at issue here. They're
Obviously not, right?
different. Right. They're very, very different animals. And I'm not certain, and I have much more limited experience with the Public Sector Act. I don't know if there is a stated humanitarian purpose. I can tell you in application, the Public Sector Act is anything but a humanitarian application, which I believe is there's a pending bill before the council to actually bring that in line with the Private Sector Act. But in that sense, without knowing what the council's specific statements are as to why they chose to bring apportionment into the Public Sector Act, I really can't speak to it, but I think it kind of goes to my last point, which is if the council intends for that to be the case, they have to state, they have to articulate a reasonable basis for why they are subtracting benefits that injured workers were previously entitled to. I should say eliminating benefits or decreasing benefits, which in the Public Sector Act, they very well may have done, but in the Private Sector Act, they have not done at any point in time. All they've done is really shift who is responsible for payment of full compensation to the injured worker. The injured worker has never been asked to bear the burden of a prior injury under the Private Sector Act, whether it was before the 1993 amendments, before the 1999 amendments, or at the present time. It's only been a matter of whether the employer was responsible, or the employer was responsible but would be reimbursed by the special fund, or the employer was responsible and the special fund was responsible. But the whole purpose of the act is that an injured worker should never have to bear the burden of their pre-existing conditions. That all is borne by somebody other than them. They're still always entitled to their full compensation under the aggravation rule and under the humanitarian purpose of the act.
Thank you.
All right. If there are no further questions, I'd like to thank both counsel for your briefs and arguments in this case, and the case is submitted. And at this time, you're free to exit our virtual courtroom.
Thank you.
Thank you, Your Honor.
Thank you. All right, good morning, council. This is our third and I think Counsel for Pelley may still be connecting to audio, so we'll give him an additional moment.
Good. She's talking, but I can't hear her.
I'm not talking now, but can you hear me now, Mr. Curtin?
Good morning, Your Honor.
All right, good morning, council. This is our third and final case this morning for argument. This is in the matter of Howard University versus PNC Bank et al. Council, are you ready to proceed?
Yes, Your Honor.
All right.
Thank you, Your
Counsel.
Honor. May it please the court. Michael Keneally on behalf of Howard University, and I'd like to reserve 3 minutes for rebuttal if I may.
All right, thank you.
The university filed this action 3.5 years ago to effectuate the wish of Dr. R. Frank Jones that his estate be used to set up an endowed chair of urology at the university's College of Medicine. Initially, this was not a controversial request because everyone agreed that the 3 trusts Dr. Jones had originally set up had accomplished pretty much all they were supposed to accomplish, and were now just eating into the estate in the form of trustee fees. It was costing between $80,000 and $100,000 a year just
Well,
to
Mr.
provide.
Mr. Keneally, if I could jump in, I think there was agreement, as I understand it, on the issue of Dr. Long wanting his residuary estate proceeds to create a chair at the Howard University School of Medicine and a revolving loan account for needy students at the university's medical school. And I think that may be where the agreement ends, as I understand the parties' briefs. And the issue before the trial court was, how is it that Dr. Long intended to create this endowed chair at the university's dental school? And so what we have before us is the trial court's interpretation of what they believe was the intent of the testator, Dr. Long. And I guess I want to start by asking whether your position is that the will is unambiguous, or is the will ambiguous in some of its terms? And if so, what's the appropriate standard of review for us here?
Sure, Your Honor. And we would submit that the will and the charitable trust agreement are unambiguous in this regard. And therefore, that the court's standard of review is de novo, because the Superior Court said that the judge was resting his decision on the documents, and that the extrinsic evidence merely reinforced them. So we submit that the interpretation of the documents is an issue of law for the court de novo. And I think both sides actually do agree on that. And it's only if you get to the extrinsic evidence that there would maybe be a potential clear error standard of review for any findings of fact that the Superior Court made.
Okay, I apologize. I've been calling him Dr. Long as Dr. Jones. I apologize. Well, then I would appreciate it if you could walk us through, because I think that there are provisions in the will that are key. But it seems to me that if we were to adopt the university's view, which essentially is that the remainder from the charitable trust, which was the Inter Vivos Trust, should be combined with the remainder or residuary from the Education and Income Trust and deposited directly into the university's endowment fund. In order to, I guess, give effect to that interpretation, seems like we have to ignore a lot of the language in the will referencing an additional trust fund.
Your Honor, I'd be happy to address those provisions, and I disagree that we would need to ignore anything on the university's reading of the documents. In fact, it's the Superior Court's reading that we submit actually ignores some of the language in these provisions. So let me start, if I may, with the will, which I think we all agree is kind of the paramount document, since it was the final of the documents.
Keneally, excuse me one moment. Can I ask perhaps Mr. Curtin if you could mute your microphone if you're able to? I'm hearing a lot of feedback as Mr. Keneally is speaking.
I'm sorry, is it mine that you're hearing feedback from?
I believe so, if you're able to mute it and then unmute at a later moment.
I think we can do that, or have somebody do it for me, actually.
That's okay. I think it's a little better now. So Mr. Keneally, you can proceed.
Okay, thank you, Your Honor. So let's begin, if we may, with Article 6 6A in the will. This is the JA 32, if you have that pagination.
Yes.
And this is the provision that says, it is my intention and direction that the residue of my estate, subject to, and then I'm going to skip over the other provisions in the documents, like the bequests.
But you also
come
skipped
to-
over to the point of, okay, go ahead. I think that's
come
where-
to rest in Howard University in trust to support a chair of urology. That's the first provision that we point to that suggests that this transfer is meant to go to the university. Then if we skip over to Article 10th, this is 4 pages later on JA 36.
But what about the remainder of Article 6A in that last paragraph where he says, it is my wish, let's see.
Yes.
If possible, that the university include in the designation of the trust, which seems to comport with the appellee's interpretation of a trust fund, which is also referenced later in the will, but it says include in the designation of the trust administrator.
Right.
So what's the difference between a trustee and a trust administrator?
Well, that is a great question, Your Honor, because this provision here, which Your Honor pointed to, does say trust administrators, but I would note that it's suggesting that the university has the authority to make this appointment of the trust administrators, although they if possible, here it says, Dr. Jones wished that these 3 individuals at the university be included. Then if Your Honor knows that there's this attachment to the will, a diagram that appellees have relied on. There, it's referring to the individuals as trustees. So we submit that this is a sign that the lingo here isn't used with absolute consistency and precision. But to us, the more significant point here is that these trust administrators were subject to the appointment power of the university, which is something that is not true under the Superior Court's resolution, because the Superior Court appointed the new trustees, Mr. Curtin's clients, to oversee this new fund.
Well, but the language in the charitable trust and in, I think it's provision 7 of the will or 10 of the will, talks about a trust fund.
Sure, that's Article 7th, Your Honor. And it does say that upon the completion of the purposes of the educational trust, this is JA 35, the trustees, meaning the trustees of the educational and income trust, shall transfer, convey, and pay over any remaining principal and income of said trust to the Esther S. and R. Frank Jones Trust Fund, which is designed to support a chair of urology.
Now, when I hear Esther S. and Frank Jones Trust Fund, that language to me suggests some inconsistency with the fact that the university is the trustee. That this language seems to suggest, as I believe the trial court interpreted it, that there is a separate trust fund as referenced in the charitable trust and referenced in, I think, the provision of the will as well.
Well, there's nothing here that suggests who the trustees of this trust fund, assuming it is a separate trust, are supposed to be. I mean, we've already talked about the language that discusses the trust administrators that are subject to Howard's appointment power, but there's nothing in any of the documents that suggests that a particular trustee would be in charge of the trust fund that's different from the university or the university's personnel. There is that language as well in the charitable trust agreement of which Your Honor referenced. This is Article 2nd of that document. I'm sorry to jump around to these different provisions, but there are quite a few provisions that are relevant here. In Article 2nd of the charitable trust agreement, the direction there is upon the death of Esther S. Jones or R. Frank Jones, whichever shall last occur, the trustees of that trust, the charitable remainder trust, shall distribute all of the then principal and income of the trust, other than any amount due.
I'm sorry, Mr. Bailey, which language from the trust fund are you reading? Is that JA 23?
I think that's correct, Your Honor. This is at Article 2nd.
Okay.
Yes, JA 23, you're correct. And here the instruction is that the trustees of the charitable remainder trust shall distribute all of the then principal and income of the trust, other than any amount due to the life beneficiary hereof, to the College of Medicine of Howard University, under, through, and upon the conditions of the Esther S. and R. Frank Jones Trust Fund. Again, so there's that language of the trust fund. But as we pointed out in our briefing, the language trust fund can be used with less than complete precision, perhaps, but it can be used anyway without great abnormality to refer to a restricted fund. And we think that that's really what was happening.
But I think that I'm hearing quite a bit of feedback. I don't know if I'm the only one hearing the feedback. So I don't know. That language, the Esther S. and R. Jones Trust Fund, to me, the clearer interpretation is that it's a trust fund that Dr. Jones created. Your interpretation to me relies a great deal on the testimony of the Howard University endowment person, Mr. Bennett, I believe it was.
That's correct, Mr. Bennett.
Because Mr. Bennett's testimony was that's how trust funds are now, or at a particular point in time, set up. That must have been what Dr. Jones intended, but there's no indication that at the time Dr. Jones did his charitable trust or his will, that was in fact the process of how of how endowment chairs were set up, or that Dr. Jones was even aware that was the only way, which is what you seem to suggest in your briefing, to set up an endowed chair at Howard University. And so, I have trouble visualizing your interpretation that the Esther and Jones and R. Jones Trust Fund is simply references money that was meant to be plopped into the larger university endowment fund. It read more naturally, it seems to suggest that the monies would reside in the Esther and Frank Jones Trust Fund, and that trust fund could disperse to the university the monies to set up the endowment.
Well, I would point as well to Article 10th, which we haven't yet discussed in the will. This is JA 36, because there the trust fund is actually referred to. This is in the second sentence that begins, "Further, it is my desire that to the extent that the income of the endowment fund." So there, the trust fund is being referred to as an endowment fund. So again, I think it's hard to view trust fund as referring to what the Superior Court created, which is an outside trust, not overseen by Howard or the trust administrators that Article 6A specifies, the director of the hospital and so forth.
Well, no. I don't know if I would agree with the characterization that what the Superior Court did was create an quote unquote outside trust fund. I think what the Superior Court, as I understand the order, purported to do was to give effect to the provisions in the will and the charitable trust agreement that reference a trust account, the Esther R. and R. Jones trust account, an entity separate from the university that would receive the residual area from the receiving state, manage those funds, and disperse those funds to the university to create the endowed share. Why can't that be done? What's the issue with that?
Well, Your Honor,
so concerned about that option, since the monies will ultimately get to the university through that what's now been deemed the indentured trust, but essentially was the court's effort, as I understand it, to give effect to the provisions in the will, presumably executing the wishes of the testator, Dr. Jones, to create a Esther Jones and Dr. Jones Trust Fund.
So the issue that the university has with that, Your Honor, is really that there's no guarantee yet when, if ever, these funds will be transferred to the university. They'll come to rest in the university in sufficient amount to endow the chair of it. Dr. Jones, everyone agrees, wanted to be created.
But there seems to be a presumption on the part of the university that it won't. When the will, if it's interpreted as the trial judge determined, specifically directs the trustees to do what Dr. Jones wanted. And there's certainly sufficient money, upwards of $6 million, at least at the time of this litigation, which is more than enough beyond the $4 million minimum that's required to create an endowed chair. Why is the university presuming that this is going to be dribbled out essentially to the university in a way that for whatever reason would not effectuate the intention of the Dr. Jones and his estate? Why wouldn't you presume just the opposite? There's enough money there. They wanted a trust account that was operated by their designees. And they wanted that trust account to then make determinations about the disbursement to the university and the loan program for needy students.
I think the university is concerned because when the original individual trustee, Mr. Reynolds, proposed this idea of the new trust to the Superior Court, it was on the assumption that there would be a yearly amount of money that would be used to pay the salary of a professor of urology at the university. And there's that's
where I'm sorry to press you on that point, but I don't understand where that assumption came from about the yearly disbursements, as opposed to a disbursement of at least the minimum $4 million, which the university says apparently is an absolute requirement for setting up a endowed chair. Where does that assumption that it would only be dispersed on an annual basis come from?
Well, it's really just from the history of how this case was litigated below. And there's nothing in the order itself, certainly, that says it has to be annually. It says, in fact, that the trustees in their discretion should distribute as much, including up to all of the principal and income that they in their discretion think should be distributed to Howard. So there's certainly room for them to reach that conclusion, but they have not said, to my knowledge anyway, and certainly not in any of the pleadings, that they intend to do that, let alone on a given time frame. Now, I don't know, maybe Mr. Curtin will say otherwise here.
Has there been any discussion since the creation of the trust fund and appointment of the trustees about supporting or endowing the chair of the chair for urology?
Not that I'm familiar with, Your Honor. There has been discussion about paying the contingent income beneficiary, who I understand, this is Sandy Brothers, who I understand has been paid now. But as far as I know, the way things stood when we filed our appeal, there was still uncertainty about who the corporate trustee for the new fund trust was going to be. Because PNC Bank, who has been the corporate trustee for these trusts, did not wish to any longer be in that role, in large part because it's difficult for PNC Bank or any corporate trustee, I guess, to oversee a loan fund program, which is the other, purpose of this money. So as far as I know, that we're still in a state of limbo, and I think the three trusts still retain custody of the assets, and we're waiting for the resolution of this case to see what happens with an appointment of a new corporate trustee and with respect to funding any of the purposes.
So what would be the problem if the trustees did disperse the monies on an annual basis to the university?
Well, the problem would be that there would be no guarantee that funding would exist year in and year out. And in order to recruit world-class, do a nationwide search for an endowed professor, which is, what an endowed chair allows you to do, the university would be at the discretion of non-university people about how much money would be available in a given year. And you cannot make a commitment to a tenured faculty member that depends
Well,
on those kinds of
but the
contingencies.
will does direct and request that in addition to the trustees, that the appropriate administrators at the medical school and the Department of Urology be appointed as administrators. Now, this makes the distinction between trust administrators and trustees. That in addition to the trustees directed by the state for the trust fund, Dr. Jones bequeathed or requested or directed that administrators from the university be a part of this, presumably to assist in recruiting world-class members and ensuring that it's funded appropriately, meaning that the monies were timely and appropriately transferred to the university as needed for the endowment.
Well, the only role that the trust administrators have under the will, and this is Article 6A again, is to have discretion over whether to create a loan fund for the low interest rate loans. And under the terms of the indenture that the Superior Court ordered created here, and this is in the joint appendix, attached to the Superior Court's order, the trust, there's no one from Howard University that has any legal authority over the amounts of distributions to Howard University, either for loan funds or for, let alone the endowed chair. So we really don't have that guarantee.
The will didn't require that. Will required setting up the trust.
Well, again, Your Honor.
And then having some advisory members, if you will, who would be trust administrators who could provide the important university perspective at the medical school on the needs for that chair. But I'm sorry, I see that both of my colleagues have questions. I have more questions, but I'm going to stop talking for the moment because.
I just wanted to ask about a portion of your brief that caught my attention in particular, and it's this discussion about what you describe as the change in position of Mr. Reynolds, who apparently helped draft the trust agreement and will. And you say that he had agreed initially to the distribution to the university to in trust to be administered by the university, and then in later communications expressed his own opinion that should not occur, that the money should stay within an outside trust. What, if anything, did the trial court have to say about that change in position?
I don't recall the trial court addressing it, Your Honor, and the trial court did say, as I noted earlier, that it was relying on the documents primarily. And I don't know if that, I'm speculating now, and I hate to do that, but I don't know if that had any part of it. But Your Honor is correct that in the answer, Mr. Reynolds filed back in October of 2017, this is JA 56, he expressly consents to the distribution of the charitable trusts to Howard University, admittedly in trust, but assuming that they could show to the Superior Court that they had adequate safeguards for the money in the trusts. So we take that to be a bit of a concern then when Mr. Reynolds later testified that he thought that the will documents didn't, and the trust document didn't permit transferring the money to Howard University. It's unclear why he would have consented to that arrangement initially, if that were the case. So we think that it was improper to rely on his testimony for other reasons as well. And that may be why the Superior Court really did focus on the documents.
All right, I thought that would be the answer, that the court was looking to the documents only, but if the court had said something about it, I didn't want to miss it. Thank you.
Mr. Keneally, early on, you opined that the documents were not ambiguous and that we should conduct de novo review. Do you consider the testimony of Mr. Bennett from Howard University to be extrinsic evidence?
Yes, I think it's fair to call it extrinsic evidence, Your Honor. In part, Mr. Bennett was qualified as an expert to testify about some of these concepts, like what an endowment is and so forth. But we also cite legal dictionaries like Black's Law Dictionary for that. So I think that's permissible extrinsic evidence, but not necessary extrinsic evidence in this case, because again, we would.
It seems to be helpful from your point of view, at least, to clear up some things. What did Dr. Jones intend? And so I'm wondering if your reliance on his testimony doesn't actually reveal that you think there is ambiguity in the documents.
Well, I think I would argue it in the alternative, Your Honor. I think you can tell just from taking the documents at face value that Dr. Jones intended for all of the principal and income of the charitable trust, that's the language from that agreement itself, to go to the College of Medicine of Howard University. And I think you can make similar inferences that all of the estate assets, all the residue of the estate were to go to Howard University, just from the documents within the four corners. If then there becomes a question of ambiguity with respect to the use of the term trust fund or endowment fund, then it's certainly, I think, appropriate to go beyond that, to look to proper sources of extrinsic evidence to figure out what these terms actually mean in their usual sense.
One of the things I find lacking in your presentation is evidence about what somebody writing in 1978 would have understood that these terms meant without ever having consulted, so far as we know, with officials at Howard University.
Well, I think it's fair that we don't, there's no evidence in the record, and I'm not aware of the state of facts in the 1970s about what amount of money needed to be transferred to the university in order to endow a chair. We don't have those facts in the record, but we do have information about what these terms meant in their usual sense, like endowment, for instance. As of 1968, which is the year that Black's Law Dictionary revised 4th edition, which we cite in our briefing, was published. So before 1973, when the Charitable Remainder Trust was founded, and before 1978, when the will was executed. So there is some evidence of what these terms meant at the time, but it's fair to say that we don't have all of the facts about how the endowment of Howard University worked at that time.
This comment may itself be extrinsic evidence, but as a university and graduate, I have the distinct impression that universities are happy to get their hands on money any way they can. And they're prepared to be somewhat flexible if they need to be in order to get the money. So it seems unusual that you're not willing to bend a little bit here in order to achieve the purposes of Dr. Jones, and at the same time to get a whole bunch of money to endow a chair.
Well, Your Honor, I don't know that I would agree that we're not willing to bend a bit, but it depends, I guess, on what kind of bending we're talking about. I mean, the testimony was clear in the trial court that as far as Howard is concerned, and as far as it knows every university is concerned, there's no way to endow in a chair without an actual endowment where the university has control over the money that is used to fund the chair. And it has never endowed a chair without, at least $1.5 million to $2 million of a transfer. And so, we could maybe have a lecture series.
Oh, that was $4 million.
It's $4 million in the College of Medicine, Your Honor. It varies a bit from one school to the next, but for the university's College of Medicine, it's $4 million, and that's in the record and remains true today.
But was that in the record at the time these wills, the will and the charitable trust were created?
No, I don't know.
That was my initial question, and that's the question that Judge Fisher asked you as well. And that seems to be what a huge assumption that your client's argument is based on. Can I ask another about a statement you made in response to Judge Fisher a moment ago, where you said that on de novo review, the four corners of the will make clear that the remainder of the charitable trust was to go to Howard University. Can I ask you to look at the joint appendix, page 42, which is the diagram? I think it's kind of unusual that you'd see a diagram attached to a will, but it was included in the will to show how the money should flow from the specific trust. And I wonder, as I look at this, I have difficulty squaring what this says with your statement a moment ago that the money from the charitable trust was intended to go to Howard University. When we look at the diagram, it shows the money from the charitable trust going to the Esther S. and R. Frank Jones Trust Fund to support a chair of urology and to support in low-income student loans. And so I guess I don't see why that can't be given effect and still address the concerns of the university of sort of stepping out and hiring an endowed chair of urology and then running out of money the following year. I mean, it seems like this document or this page of the will seems to make clear that it is a private trust, the Esther and Frank Jones Trust Fund, that is to receive the monies. And the arrow from the Education Trust goes to that Frank and Esther Jones Trust Fund, and the arrow from the Income Trust Fund goes to the Education Trust and then into the Frank and Esther Jones Trust Fund to do what we seem to all be in agreement was the intention of the testator to do. And it seems to me that the assumption that the money is only going to be, and this is my word, I know this is not your word, Mr. Keneally, dribbled out to the university in drips and drabs that would be insufficient to sustain the chair. Those seem to be assumptions that aren't yet supported by the record. And certainly there would be redress if the trustees don't carry out the intention and purpose of the trust.
May I just respond directly about this diagram, Your Honor? Because
Yes.
it's entirely consistent with the view that I'm suggesting here of interpreting trust fund to mean the endowment fund, which is a restricted account.
Yeah, but if to read it that way, wouldn't it, the way that you're suggesting, wouldn't it need to say the Howard University Trust Fund or the Howard University Endowment Fund? Here it says Esther and Frank Jones.
Well, I don't think it would need to say that, Your Honor, because it's common for these endowments, specific funds to exist at universities. They're segregated accounts for accounting purposes, and it might be the Esther S. and R. Frank Jones Chair of Urology. So I think it's fine to have that those names attached to it, because that's how often it works, where you have a dedicated account in an endowment that is only restricted to specified purposes as the donors intended. And I would also point out the fact that there's the second arrow below that box.
But it could also work the way we've suggested, that this was a private trust fund that the testator intended to set up, and that fund would then be responsible for dispersing monies into the university's endowment fund.
I don't think it could, Your Honor, for two reasons. The first is that there's arrow below that describes low-income loans to medical students. That's a second step from the trust fund to those students who are receiving the loan funds. There is no arrow
But it
pointing.
says in trustees' discretion. And so since that arrow is coming from the Esther and Frank Jones Trust Fund, I think it's a reasonable assumption that it could be the trustees of the Frank and Esther Jones Trust Fund who have the discretion to administer the low-income loans to medical students. And if it's a private trust, they certainly could do that.
And the other point I was going to make, Your Honor, is that we covered Article 6A originally, where it talks about the trust administrators, and they're the ones who have discretion to to set up these loan funds. So if you have to read these two provisions in our view together, and together they suggest that it's not outside trustees like Mr. Curtin's clients who have the authority over the loan funds, but it's if possible, the university's choice of the director of the hospital, the chairman of the Department of Surgery, and the chairman of the urology department. And so the discretion for the trust funds, for the loan fund is supposed to be in those three Howard University personnel, not other trustees. And then there's just no other arrow pointing to a second step where the trustees or the trust administrators or whoever is distributing either corpus or income from this trust fund to the university's College of Medicine.
But I'm not sure you need that. If you look at the box that says Esther and Frank Jones Trust Fund, and within that box it says to support the chair of urology at Howard University, excess income to provide. I mean, the steps are within that box. That is what the trust fund is supposed to do. So I understand that we differ on this point, Mr. Keneally, and I shouldn't say differ, but I'm not yet persuaded, and I'm as I look to hear from Mr. Curtin and your further arguments on rebuttal. I
understand I'm over my time, so I'm happy to come back on rebuttal, Your Honor, if the court will have me.
All right, of course, of course. Thank you. Mr. Curtin?
Good morning, Your Honor, and your colleagues. I'm Michael F. Curtin on behalf of the trustees of the Frank Jones and Esther Jones Trust.
Can I start by asking you the same question I asked Mr. Keneally? Have the trustees funded dispersed any money to fund the endowment?
They have not, Your Honor, because the order that was entered by the trial court has been appealed, and until the appeal is resolved, all of the money is in fact sitting with the corporate trustee because of the fact that there was an appeal of the trial court's decision, which we feel laid out the appropriate way to proceed. Since it's on appeal, nothing has happened and will probably not happen until there is a resolution of this. Your Honor, if I may, I would like to first just respond to Judge Fisher's comment about a university and a contributor creating a fund, an endowment fund to support a particular activity. It is hard to believe that if Dr. Jones were alive today and showed up at the doorstep of Howard University and said, I have $6 million plus, my intention is to create a fund naming a corporate trustee. Take, for example, the Bank of America, because it is one of the largest trust companies, corporate trust companies in America. And the obligation of that trustee, along with two individual trustees, would be to distribute all of the income and as much of the principal as needed to fund the R. Frank Jones and Esther Jones chair of urology at the Howard University Medical School. I find it difficult to accept the fact that if that proposal were made today, that the university would say, no, we cannot take that because we must control the money and the investments. This is, quite frankly, if Dr. Jones were alive today and that was the proposal made, I seriously doubt that we would be having this argument this morning in the Court of Appeals. As a matter of fact, the document, when read as a whole, as the trial court did, specifically sets forth what is to happen with his funds.
Okay, Mr. Curtin, may I jump in just a little
Yes,
bit
Your Honor.
with some specific questions for you? What was the trial court's authority for creating this quote unquote indenture trust? was it the statute, the will, the charitable trust? What,
Well, I think what the trial court was doing was trying to glean the intent of what Dr. Jones did in his charitable trust and what he did in his will.
was he creating, was he
The
attempting?
Uniform
the trial
Trust
judge-
Act.
Oh, I'm
sorry.
sorry. I apologize, Mr. Curtin. I was just going to follow up briefly to clarify. In your view, was the trial judge essentially creating the quote unquote Esther and Frank Jones Trust Fund when he created the indenture fund, or was it a whole new other trust fund?
Oh, no, I think he was just trying to have a document to serve the intention of Dr. Jones and indirectly Mrs. Jones to carry out the intent articulated in the 1973 and 78 documents. And I think the trial court did that under the auspices of the Uniform Trust Act as adopted by the District of Columbia.
Let me ask a question on that point. The Charitable Remainder Trust was created by a freestanding document created in 1973. Although when you read that, it sounds like there is another document that at the same time is a will. Do you agree that no will had been written in 1973?
I can't agree or disagree with that, Judge. I know there's none in the record. I know the will that was finally admitted to probate upon Dr. Jones's death was signed in 1978. I do not know, and the record does not reflect earlier dated will.
Fair
I
enough.
would infer that there may have been one.
That 1978 will, do you think it succeeds in creating the Esther and Frank Jones Trust Fund
I
that we're
certainly-
talking about?
I think it does, yes.
So to go to the Chief Judge's question, the other Judge Fisher was trying to perfect that document to better carry out the purposes of the trust that had been created in 1978?
I wouldn't say to better perfect it. I think he was trying to create a document that would in fact carry out the intent of Dr. Jones as gleaned from the 73 and 78 documents in a way
Thank
that
you.
would be practical.
Can I ask another question to follow on that, that I asked Mr. Keneally? What's the difference between a trustee and a trust administrator as the two terms are discussed in the charitable trust agreement and in the will?
Well, as I read the trust administrator entity, that person or people are to deal with the issue of the loan fund and not to deal with the corpus of the trust. That they have a specific narrow responsibility if in fact there are funds available for the loan fund, which is a very discretionary thing, as I hasten to point out. But if there are those funds, it is the administrators that are referred to in that document that carry out that intent, and not the corporate trustee.
Is there any basis in the record for this concern, which I think has some merit, voiced by Mr. Keneally, that the funds from the estate would be provided on an annual basis in amounts that potentially would be insufficient to sustain an endowed chair? Where does that concern or notion come from, as far as you know? Is it based on intentions voiced, or what's
Based on the record, as I have read it and reviewed it, Your Honor, I believe that there was some concern because the university wasn't controlling the investments and wasn't controlling the income flow, that somehow a trustee would on its own or her own or his own ignore the terms of the trust and not make a distribution to the beneficiary, i.e. The Howard University Medical School, to endow the chair. It's sort of like saying, we want to make sure that we're the only ones that can do that job, so we don't want anybody else, regardless of what the intent of the donor was, we don't want to have a third party involved. I can find no other justification for that concept. And I think more to the point is, this is a trust device. Trustees are fiduciaries. They have a fiduciary obligation to presume that they will breach their duty to carry out the intention of Dr. Jones, and therefore not carry out what Dr. Jones wanted, but let us, the university, have the money, and we will make sure that the money gets paid out, is quite frankly circular. It sounds like it would be easier, clearly, for the university to have that control, but that isn't what Dr. Jones wanted. Dr. Jones, his intent was to have this trust fund, and he specifically named a corporate fiduciary and an individual to be the trustee of that fund. And it would seem to me that his intent should be carried out, so long as it doesn't create any disharmony with what Dr. Jones wanted. I mean, he said, I want this to be a separate fund. He said, I want, at that time, National Savings and Trust Company and Arthur Reynolds to be the trustees. That was certainly his prerogative. What's happened in the trial court is the other Judge Fisher, as your colleague referred to him as, merely had a document crafted that would clearly carry out Dr. Jones's intent to have the fund created.
So a trust, you don't have to have, in other words, I hear what you're saying is that if the will clearly laid out his intention to create and set up and have a trust control this, it didn't need to attach a document that says this is the trust. That what the trial court is doing here with the quote unquote indenture trust is effectuating the trust that was created by the language in the will.
I think he was, I wouldn't say he was effectuating the language, but he was just carrying out what the trial court found to be the clear intent of Dr. Jones's, to have this trust, have it separate and apart from the university, have all of its income, as much of its principal as is needed to support that chair. Now, again, that's the judge in the trial court looked at the documents before him, looked at the record before him, and made, as he is charged to do, to glean the intent and as closely as possible have a document prepared that does in fact carry out Dr. Jones' intent.
Can I ask you a couple of
Mr.
questions? I'm sorry, go ahead, Judge Thompson.
I was just going to say, I take your point, Mr. Curtin, about the fiduciary duty of the trustees, which perhaps does not warrant a concern that they will not do their duty and serve the purposes of the trust. But I wonder how that squares with the language of the new trust that the court directed be created, and that talks about the trustees distributing income and principal as they in their sole discretion shall determine. There's something that doesn't quite jive with sort of an assumption about them doing their duty to distribute funds to support an endowed chair, and they're having sole discretion as to the amount of income and principal to be distributed to do that. What's your response to that? I'm sure you have one.
There is a there's a guidepost in that document, and they are to deal with and use as a reference point what other endowed chairs at Howard and other universities and other medical schools use. so that it's not a blind discretion. We give you a penny this year and $1 next year. They've got to comport with what is needed by Howard and judge that against what is needed or used in other medical schools and universities of similar size and makeup. That's what I think is the response to your honor.
Does that mean that their judgment on this is or is not reviewable? Would or would not be reviewable?
Oh,
Is
it
that
certainly would be,
sole
would be
discretion?
reviewable. It clearly would be reviewable, Your Honor, if in fact they didn't use the guidepost. Now, admittedly, that would mean that Howard would be back in the Superior Court and saying, as a pure example, the Bank of America and this Young are not carrying out their duty as trustees. They are saying in their discretion, they don't have to give us a dime. When in fact, Howard has shown them that they need X $100,000 a year to carry out the work of this particular endowed chair. And I would suggest to you that although there is discretion, that discretion that kind of conduct would be an abuse of discretion, and the trial court would clearly find them, the trustees, to be in breach of their duty and probably subject to removal. So yes, they have discretion as opposed to having a dictation come from a third party, but clearly they have to exercise their discretion in accordance with their duty as a trustee and the intention of the document. The document makes pretty clear what has to happen to the income and principal on an ongoing basis.
Mr. Curtin, let me ask you a question about standard of review. I understand your brief to say we ought to review the documents de novo, but if we have to resort to extrinsic evidence, then the standard becomes review for clear error.
That's correct, Your Honor.
I'm inclined to think that we're in extrinsic evidence land and that our review is whether the trial court was clearly erroneous in its finding of intent. Do you agree or disagree with that?
I think I would agree, Your Honor, that because of the fact there was some testimony, both by Mr. Bennett and by Mr. Reynolds, that maybe there is an extrinsic evidence that has to be looked at. But you have to also say, was there clear error? And we would posit that there was no such error.
There's debate in the briefs about when extrinsic evidence is appropriate and what kind of extrinsic evidence. Do you think the trial court erred in any respect in relying upon the essentially submissions of Mr. Reynolds?
Well, I think they relied on the submission of Reynolds and Mr. Bennett. At least he alluded to that. There were no other submissions made, Your Honor. I mean, he can't go out and manufacture evidence. It has to be presented to him. That was the record that he was presented with.
And in your view, did he properly consider all of that from Mr. Reynolds and Mr. Bennett?
I believe he did. Yes, Your Honor.
Mr. Curtin, the ambiguity that I see existing in some of these provisions, tell me how you suggest it be reconciled and how you understand the trial court reconciled it. So, for example, in I guess paragraph 7th or 7th section, which is at the joint appendix, page 35, JA 35, it says, upon completion of the purposes of the Frank and Esther Jones Educational Trust, the trustee shall transfer, convey, and pay remaining principal and income of said trustees to the Esther and Frank Jones Trust Fund, which is designed to support a chair of urology at Howard University College of Medicine.
Okay.
If any such department exists, if not, a chair closely related department. Then in paragraph 10 of the will at joint appendix 36, it says, it is my wish, desire, and direction that the transfer of the corpus remainder of the trust herein to Howard University be made for the purposes of and upon the condition that the said university will establish an endowment to support a chair of urology and research in the medical school if such department exists.
Your Honor,
There seems to be some tension in between those two provisions. What is your understanding of how the trial judge reconciled that and how it should be reconciled?
I think the trial judge reconciled it by establishing that the overarching intent of Dr. Jones was to create the chair of urology and to make sure funds were sufficient to maintain that chair. And he chose, the trial court judge, realizing that was the overarching concept, that the only way that could be done within the context of the will and the charitable trust would be to create this trust that he has directed be done. That there would be all the money would be poured into that trust fund, and it would be made available solely for the benefit of Howard University Medical School to maintain their chair of urology chair. There's no other way I can suggest that the trial court, that was the trial court's dilemma was trust fund. If you look at all of the documents in their totality, Dr. and Mrs. Jones had a pile of money. They wanted to take care of family and friends, and then they wanted to maintain this amount of money for the chair of the chair at Howard University Medical School. And the trial judge, reading Article 10, reading Article 6, reading what his intent was as to what would happen to the 1973 charitable fund, came up with the concept that here, the way to marry, to capture Dr. Jones' intent would be with this trust and have the money utilized for the way the trust that the court directed be drafted, have the money flow that way.
All right. Thank you, Mr. Curtin. Mr. Keneally, you reserved a couple of minutes for rebuttal, and we will hear from you now.
Thank you, Your Honor. Just a quick point about Mr. Curtin's suggestion. It's hard to believe the university wouldn't, take the money, and it goes to Your Honor's question, Chief Judge Blackburn-Rigsby, about what's the basis for Howard's concern that the funding would be on a yearly basis rather than, a lump sum of $4 million, for example. And I think you heard Mr. Curtin say that if the trustees distribute no money or dollar, then we'd have recourse to go to court and argue that that's an abuse of discretion. But his alternative was X $100,000 a year. And that's why we're concerned that there's no commitment in the trust indenture or from the trustees themselves of donating the money that on Howard's website, it says you have to donate $4 million for certain schools to endow a chair. This is not a requirement that we've made up or that's unusual for endowed chairs in universities. So we've the record is pretty clear that you can donate money on an annual basis, but you can't donate money on an annual basis until you get to the $4 million threshold as a lump sum that Howard manages and oversees to endow in a chair. And so I would implore the court, if it thinks that the Superior Court's effectuation of Dr. Jones's intent through this new trust or the trust fund or whatever we want to call it, it is not clearly erroneous or is warranted on de novo review, at least provide the parties some guidance on this question of whether the money that is needed under the unquestioned policy of the university to endow a chair actually has to be transferred to the university, because otherwise we're going to end up back in court and we're going to be eating up the trust's assets on legal fees and trustee fees rather than on loan funds and an endowed chair. And so I would ask the court to take that into consideration. And with that, we asked the court to reverse the trial court's ordering of this new trust, because we think you can effectuate Dr. Jones's intent fully well through the mechanism of the Howard University endowment. The Uniform Prudent Management of Institutional Funds Act requires the university to use endowment funds for the purposes for which they're restricted when they are restricted. And so there would be plenty of oversight.
Mr. Keneally, can I ask what the legal basis you assert would be for reversal of the trial judge? Is it that we would determine that the factual findings of the trial judge were clearly erroneous, or was there another legal basis for reversal?
Well, we don't think there were really any factual findings. I mean, the trial court, announced his decision. The other Judge Fisher announced his decision in open court. That he didn't issue, findings of fact necessarily.
Well, but if we say that if we are of the view that there is ambiguity in the will and that extrinsic evidence was admitted appropriately, what is the standard of review then?
I still think you're left at the end of the day with a legal question. I mean, because Judge Fisher didn't say, I find Arthur Reynolds' testimony credible and believe that he told Arthur Reynolds that he wanted a fourth trust to oversee this money. There's no finding like that. So you can't defer to a finding like that. I think you're then left with still a question of law, which is what was the intent of the testator based on the documents before the court. And I don't think there's really much dispute other than Mr. Reynolds' testimony about the extrinsic evidence. So I don't think there's a real question of fact before the court that is really subject to that clear error review.
Why isn't the intent of Dr. Jones itself a question of fact?
Because we didn't have any testimony directly bearing on that other than Mr. Reynolds' testimony, which for the reasons we've argued, relying on the page on Will's treatise is not admissible. This direct declaration of testator intent. We don't have a finding that rests on say we had extrinsic evidence that there was this other will out there from before 1978, and it had the terms of the trust fund as a trust in great detail. And so that was the extrinsic evidence. And we think that is indicative of the testator's intent. We don't have anything like that. And in fact, Mr. Reynolds said there was no will before the 1978 will in one of his submissions to the court.
In your view, the other Judge Fisher, he has a comment that might be interpreted to say, I did not rely upon Mr. Reynolds' testimony. I relied on the documents. But, oh, by the way, it's convenient that Mr. Reynolds' testimony supports or is consistent with my understanding of the documents. Is that what you think?
That's how I construe the Judge Fisher's statement below. But if the court were to think that it was unclear or to think that he did rely on Mr. Reynolds' testimony, then all of our arguments for why that testimony as a matter of law cannot be considered to interpret or change the terms of the documents, those arguments would come into play as well. And so unless the court has further questions, we would ask that the court reverse the trial judge's ruling insofar as it created this fourth trust rather than distributing the estate to Howard University's endowment.
All right, thank you. Thank both counsels for your briefs and your arguments today. And The case is submitted, and counsel, you're free to exit our virtual courtroom at this time.